Justice Barrett?
General Sauer, I want to ask you about a potential tension. Well, no, not potential tension, an actual tension that I see in answers that you gave to Justice Kavanaugh and Justice Kagan. You resisted Justice Kagan when she asked you whether the government would obey within the Second Circuit a precedent. I'm distinguishing between opinions and judgments here. Did I understand you correctly to tell Justice Kagan that the government wanted to reserve its right to maybe not follow a Second Circuit precedent, say, in New York, because you might disagree with the opinion?
Our general practice is to respect those precedents, but there are circumstances when it is not a categorical practice. It is, and that is not
this administration's practice or the longstanding practice of the federal government. And I'm not talking about in the Fourth Circuit, are you going to respect a Second Circuit? I'm talking about within the Second Circuit. And can you say, is that this administration's practice or a longstanding one?
As I understand it, longstanding
Really?
policy of the Department of Justice. Yes, that we generally, as it was phrased to me, generally respect circuit precedent, but not necessarily in every case. And some examples might be a situation where we're litigating to try and get that circuit precedent overruled and so forth.
Well, okay, so I'm not talking about a situation in which, you know, the Second Circuit has a case from 1955 and you think it's time for it to be challenged. That's not what I'm talking about. I'm talking about in this kind of situation. I'm talking about this week, the Second Circuit holds that the executive order is unconstitutional, and then what do you do the next day or the next week?
Generally, we follow those.
So you're still saying generally?
Yes.
And you still think that it's generally the policy, long-standing policy of the federal government to take that approach?
That is my understanding.
Okay, so, but it sounds to me like you accept a Cooper versus Aaron kind of situation for the Supreme Court, but not for, say, the Second Circuit. Like where you would respect the opinions and the judgments of the Supreme Court, and you're saying you would respect the judgment, but not necessarily the opinion of a lower court.
And again, I think in the vast majority of instances, our practice has been to respect the opinion as well, in the circuits as well, but my understanding is that has not been a categorical practice in the way respect for the precedents and the judgments of the Supreme Court has been.
So you're not hedging at all with respect to the precedent of this court?
That is correct. I believe the quotation from our application directly addresses that, and we stand by that completely.
Okay. Next question.
You're going to be standing up here in the next case saying that Rule 23 is inapt for this circumstance with this number of people, maybe with some questions that are individual, who knows. So let's put Rule 23 aside, because I got to tell you that does not fill me with great confidence. How else are we going to get to the right result here, which is on my assumption that the EO is illegal?
That would be a profoundly wrong result, but I think what I would offer is that, very similar to Labrador against Poe, what the court should be engaging here is a balancing of the equitable factors as to the scope of remedial relief, not as to the underlying merits. And our contention that this exceeds the traditional scope of equity that's reflected in the 1789 Judiciary Act, we're overwhelmingly likely to succeed on those merits for all the reasons that I've stated in our briefs.
I mean, that's a lot of words, and I don't have an answer for if one thinks. And, you know, look, there are all kinds of abuses of nationwide injunctions. But I think that the question that this case presents is that if one thinks that it's quite clear that the EO is illegal, how does one get to that result, in what time frame, on your set of rules, without the possibility of a nationwide injunction?
On this case and on many similar cases, the appropriate way to do it is for there to be multiple lower courts considering it, the appropriate percolation that flows to the lower courts, and then ultimately this court decides the merits in a nationwide binding precedent. You have a complete inversion of that through the nationwide injunctions where the district
So, General
courts
Sauer, are you really going to answer Justice Kagan by saying there's no way to do this expeditiously?
Well, I'll refer to my former answers. Rule 23 provides the tools to do so, multiple injunctions.
But you resisted Justice Kagan when she said, could the individual plaintiffs form a class?
That has never been briefed in the court below. I do not concede that we wouldn't oppose class certification in this particular case. There may be arguments that this case is or is not appropriate for class certification. And
if there were a class appropriate for class certification, you concede that that could resolve the question quickly?
Yes, absolutely.
You concede it could resolve the question quickly through precedent?
Yes, absolutely. It could do so. I mean, we obviously dispute the...
So just on that point...
This is just a very practical question, how this is going to work. What do hospitals do with a newborn? What do states do with a newborn?
I don't think they do anything different. What the executive order says in Section 2 is that federal officials do not accept documents that have the wrong designation of citizenship from people who are subject to the executive order.
How are they going to know that?
The states can continue to, the federal officials will have to figure that out, essentially.
How?
So you could imagine a number of ways that the federal officials could.
Such as?
Such as they could require a showing of, documentation showing legal presence in the country. For a temporary visitor, for example, they could see whether they're on a B-1 visa, which would exclude kind of the birthright citizenship in that context.
For all the newborns? Is that how that's going to work?
Again, we don't know because the agencies were never given the opportunity to formulate the guidance. They had 30
They're only
days.
going to have 30 days to do this. You think they can get it together in time?
They're under, that's what the executive order instructs them to do, and hopefully they will do so. Again, it's a speculative and hypothetical scenario because they were enjoined from even starting that process.
We began with breaking news and a consequential day at the U.S. Supreme Court, where in minutes the justices will hear arguments involving President Trump's controversial executive order that would end birthright citizenship for the children of undocumented migrants. 3 federal judges have blocked Trump's order from proceeding, one calling it blatantly unconstitutional. At issue in today's case is whether any of those judges or any lower court judge has the authority to check the power of the presidency nationwide. We'll carry these arguments live. And as we wait for the arguments to begin, NBC News Justice and Intelligence correspondent Ken Delanian is joining us outside the court. We also have a full slate of legal experts with us this morning. MSNBC legal correspondent Lisa Rubin, former U.S. attorney, MSNBC contributor Chuck Rosenberg, professor of constitutional law at NYU Kenji Yoshino, and former Manhattan District Attorney, Assistant District Attorney, MSNBC legal analyst Catherine Christian. Ken, let me start there at the court. Walk us through how this is going to unfold.
Hey, good morning, Anna. Well, you're first going to hear from the Solicitor General, John Sauer, who, with his distinctive voice, who famously successfully argued that presidents are immune from criminal prosecution in that case. And he's now arguing that there should not be nationwide injunctions. We'll then hear from the Solicitor General of New Jersey, who has sued Donald Trump in this case, and then a lawyer for immigrant groups and others who are arguing that there should be a nationwide injunction in this case. And again, the issue here is not on the merits of birthright citizenship. Ultimately, that may end up in front of this court, and that's an important issue. The issue here, though, is equally important. It's this question of whether a single federal judge in a federal district in the United States can issue an order that binds the whole country. And this is happening all the time now, but it's a relatively modern artifact. As far back as the 1960s, it wasn't happening very much at all. It's really exploded in the Trump era as Donald Trump has used executive orders to try to make sweeping changes in American policy, some of which many people think are unconstitutional. So, look, there are sound arguments on both sides here. The idea of letting a blatantly unconstitutional order stand in one district while knocking it out in another district could cause confusion and chaos, and the law would be different until the Supreme Court ultimately decided it. At the same time, there's the question of, what gives one judge a power to bind the whole country? Is that really what the founders intended? Some of these justices have already signaled their intent. For example, Neil Gorsuch has been a skeptic of nationwide injunctions for a long time, but it's really anybody's guess how this is going to go. We'll be able to read a lot into how these arguments unfold this morning.
Ken, we can hear, but we can't see all of the action there at the Supreme Court this morning. You did a great job working through that. What is the scene there? Are people protesting about this case specifically?
Yeah, they are. It's a typically boisterous scene out in front of the Supreme Court. There are a group of people, some with microphones, as you can hear, many with signs, arguing in favor of birthright citizenship as a bedrock of the Constitution. And Donald Trump posted on Truth Social today against birthright citizenship. I think a lot of people don't understand that, again, that's really not the issue that the court is chewing on today and grappling with. It's a different, very important issue. But, of course, birthright citizenship is the backdrop, is the case that's bringing this other matter in front of them.
And the future for many millions of families hanging in the balance ultimately here. Lisa, let me ask you, what arguments are we expecting from each side? We know there'll be John Sauer representing the Trump administration arguing before the Supreme Court. And then there are a couple of lawyers who will argue separately with their arguments on behalf of the challengers.
Right. And in asking for a stay, Anna, the government has said in its papers that the, quote, usual stay factors apply. One of those factors, as everyone around the table knows, is that you show a likelihood of success on the merits. One of the disputes here, however, is what are the merits of this case? The government wants to define the merits as the permissibility of nationwide injunctions and limit the debate today to that issue alone. You should expect to hear for the respondents who are the plaintiffs in these cases, though, that the merits are really about the underlying unconstitutionality of the president's birthright citizenship executive order, which, as Ken just noted, would limit birthright citizenship and say that it doesn't belong to people who are accidentally or temporarily in this country, but rather only to children born of people who, for example, have permanent residence or domicile in the country. That's not historically how we've understood it. That's certainly not how people understand an 1898 precedent of this court called the Wong Kim Ark case. You should listen for those three words very carefully today, because if they go into that territory, we are going to be talking about the merits of birthright citizenship and what the citizenship clause of the 14th Amendment provides.
What are you expecting from these arguments, Chuck, knowing what we know at this point?
What Lisa said. The narrow argument is about the propriety of nationwide injunctions, universal injunctions, sometimes also called non-party injunctions, the ability of one judge in one place to bind all parties in all places. That's the case. But Lisa's quite right. There is a backdrop. It's an important one. It's about birthright citizenship. The problem, Anna, is that if you have one judge in one place doing one thing and another judge in another place doing another thing, then you have a good bit of confusion and maybe even chaos when it comes to something like this.
So that's going horribly for Trump. Like, the rulings have to come down, obviously, but the arguments, they're losing the arguments. And this is my opinion. It's looking bad for the Trump regime in two ways, one of which is not strictly his lawyer's fault because it's a bad argument, like it's a bad case to bring, but one of them is the arguments they're making. They made a huge error. What they're trying to argue is that birthright citizenship should go away. But what some of the judges maybe hinted at was like, hey, could we, for example, reinterpret the Constitution in a way, and I'm not saying they necessarily agree with this, but the judges ask questions to get at like what the essence is, and sometimes you have to go to hypotheticals. They're saying basically, what if we were to say add some restrictions to it so that, you know, for example, particular groups of people may lose birthright citizenship, but it'll have to be very narrowly defined. Would you be good faith on that? And he basically said no. Because what worried the judges then is that, like, even if, like, and they haven't, because it looks like the judges are wary about giving Trump a win here. Amy Coney Barrett is at the very least. And so right off the bat, that's 4. Any one of the other 5 conservatives goes with the liberals, that's 5-4, right? What they're saying is, if we give you a universal, a partial ruling here, you're going to spit on it. You've already shown to us, Trump and Trump's lawyers, that when we tell you to do something like bring that man back, bring Kilmar back from El Salvador, you just don't do it. And so if we're going to give you a tool to, in a narrow way even, restrict birthright citizenship, we don't trust you to actually use it narrowly. You're just going to hit millions with it, and we're not going to let you do that. And so what's happening right now is that Trump is losing the arguments, at least, based on his own corruption.